Larry Hoover. In the spring of 2025, a sitting president signed a document that erased 6 federal life sentences belonging to one man. His supporters celebrated outside. His attorneys prepared for a release that never came. Larry Hoover stayed in a cell because the sentence that has held him the longest was never a federal sentence at all. 52 years before that signature, Hoover was a young man on the south side of Chicago with a reputation that had already outgrown him. He was born in Jackson, Mississippi, in November of 1950, and his family moved north to the Englewood neighborhood when he was about 4 years old. He joined a street group called the Supreme Gangsters before he was a teenager. By 1964, after the unsolved death of a rival leader named Alex Rain, he was running it. What Hoover built after that was less a gang than an administrative structure. He merged competing factions into the Black Gangster Disciple Nation, and later the Gangster Disciples, with ranks, assigned territory, and a chain of command that reached across the South Side. Members called him Chairman. Federal prosecutors would eventually describe an organization that operated like a corporation and treated Chicago as a distribution map. William Young was 19 years old. On the street, people called him Pookie. He sold drugs in Englewood, in territory the Gangster Disciples considered theirs, and by early 1973, the organization had concluded that he had taken money and product that did not belong to him. On February 26, 1973, Young was taken off the street, driven to an Englewood alley, and his life was taken there. Hoover and a fellow gangster disciple named Andrew Howard were charged. Hoover left the city, was located and arrested the same year, and on November 5, 1973, he was sentenced to a term of 150 to 200 years. He arrived at Stateville Correctional Center in Crest Hill to begin serving it. What happened inside those walls is the part of the story Illinois has never fully resolved. By most accounts, Hoover's authority did not shrink behind a wall. It expanded. He extended protection to inmates who needed it. He recruited the ones who were grateful. Prison staff at various points regarded him as a stabilizing presence on the tiers, a man whose word could keep a cell house quiet on a bad night. And while he was being credited with keeping the peace inside, he was, according to the federal case that followed, still directing an organization outside. He was serving a 200-year sentence and running a street operation from within a maximum security prison. And for years, the state's own institutions helped him look like an asset while he did it. In August of 1995, federal prosecutors indicted 39 Gangster Disciples leaders in a sweep they called Operation Headache. The evidence at the center of the case against Hoover came from a hidden microphone carried into a prison visiting room, which recorded him giving instructions. In 1997, a federal jury convicted him on roughly 40 counts, including running a continuing criminal enterprise. The sentence was 6 life terms. He was transferred to the federal Supermax facility at Florence, Colorado, where he spent nearly 3 decades in near-total isolation, and where his name became a cause. In December of 2021, Kanye West and Drake headlined a benefit concert at the Los Angeles Memorial Coliseum built entirely around freeing him, streamed for free to a global audience. So what does a presidential commutation actually undo? On May 28, 2025, President Donald Trump commuted Hoover's 6 federal life terms. The order reached the federal case and nothing else. Illinois still held a separate judgment of 150 to 200 years for the taking of William Young's life, and Illinois had agreed to nothing. Hoover was moved back into state custody, and Department of Corrections records listed him at Dixon Correctional Center. His legal team turned to the Illinois Prisoner Review Board, the body with the authority to recommend state clemency to the governor. At a hearing in April of 2026, John Gleason, a former federal organized crime prosecutor who later sat as a federal judge, argued that Hoover, then in his mid-70s, presented no risk of danger to the community. On the other side sat the memory of what the organization became. Ron Safer, the former federal prosecutor who helped bring the 1997 case, told the Chicago Sun-Times that in a state that produced Al Capone, he did not believe there had been a more notorious or more prolific criminal than Larry Hoover. The distinction matters more than most coverage of the commutation allowed for. A commutation shortens a sentence. It does not vacate a conviction. It does not cross jurisdictional lines. And it does not obligate a second sovereign to follow along. Two systems convicted Larry Hoover of two different things, and only one of them has moved. As of the summer of 2026, Larry Hoover remains in Illinois custody. The federal sentences are gone. The one handed down in Cook County in 1973 is not, and the clemency petition that could reach it is still pending. Hoover's power depended on thousands of other people carrying out instructions. The next man on this list needed nobody, and for 11 years, the thing that kept suspicion off him was the uniform he wore to work. Andrew Urdiales. He spent his shifts at the door of a clothing store in downtown Chicago, in a clip-on tie and a name badge, checking bags on the way out. Detectives in 2 states spent more than a decade working deaths that appeared to have nothing to do with one another. When the connection finally surfaced, it came out of a ballistics lab, and the man it pointed to sat down and started filling in the blanks himself. Andrew Urdiales was born in Chicago in June of 1964 and graduated from Thornridge High School in Dolton in 1982. He enlisted in the Marine Corps and was posted to Camp Pendleton, then to the base at 29 Palms in the California desert. After his service, he came home to Illinois, drove a truck for a living, and took the security job at an Eddie Bauer store on a downtown Chicago block that thousands of people walked past every day. The California years came first. Between 1986 and 1995, 5 women lost their lives to him there. Robin Brandley was 23, a college student who had spent that evening working a concert at Saddleback College and was walking to her car. The others were Julie McGee, Mary Ann Wells, Tammy Irwin, and Denise Maney. There was also a woman who lived. In 1992, Jennifer Asbenson was abducted in California, escaped, and reported what had happened to her. Her account would matter enormously later, when there was finally a name to attach it to. The Illinois deaths came in 1996, and there were 3 of them. Laura Uilaki was 25, Lynn Huber was 22, and Cassandra Coram, known to her family as Cassie, had just turned 21. He picked them up, argued with them, and ended their lives with the same handgun. 2 were left in the water at Wolf Lake, on the line between Illinois and Indiana. Coram was restrained, driven for hours across the state, and left in the Vermilion River in Livingston County. The case turned on that single weapon. Detective John McGrath pursued a ballistics comparison on a .38 caliber handgun and matched it to all 3 Illinois deaths. In April of 1997, Urdiales was brought in for questioning. Investigators told him the bullets matched his gun. According to accounts of that interview, he remarked that he supposed he would not be going into work that day, removed his security badge, loosened his tie, and began describing things no one had been able to learn any other way. So what does a case look like when it spans 2 states, 11 years, and 8 women? It looks like 2 separate prosecutions, run years apart, in 2 different justice systems. Cook County went first. In 2002, a jury convicted him in the 3 Illinois area deaths. Assistant State's Attorney Allison Perona described him to the court as a savage, cunning, predatory man who had been stopped by a combination of bad luck and good police work. The jury returned a sentence of death. It did not hold. In January of 2003, Governor George Ryan cleared the Illinois death row, commuting every sentence on it, and Urdiales was sentenced to life without parole. That left California waiting, and in 2011 he was extradited west to face the 5 deaths there. In 2018, a jury convicted him on all of them. Judge Greg Pickett sentenced him to death a second time. Jennifer Asbenson lived to testify. 26 years after she got out of that car, she sat in a California courtroom and described a man the other 8 women could not describe, which is the reason a survivor's account carries the weight it does in a case like this one. Prosecutors also had his own words from the 1997 interview given in Illinois, used in California, and never successfully suppressed. He addressed the courtroom briefly to offer his condolences to the families for their losses. The families answered in kind. Jack Riley, whose daughter Robin Brandley was the first woman he took in California, told reporters he regarded Urdiales as a mad dog that needed to be put down, that he considered him non-human, and that he was not afraid anymore. Charles Irwin, whose daughter Tammy was one of the desert victims, said it had been a long haul, but that they had gotten justice that day. One point about the record deserves a clean statement. Urdiales sat on Illinois death row from 2004 until his extradition in 2011, moving through the state's maximum security system in those years. Public records are not consistent about which specific facility held him on which date, so any confident claim about a single address for him should be treated carefully. What is documented is Illinois death row and the transfer that took him out of it. As of today, Andrew Urdiales is dead. He was found in his cell at San Quentin State Prison on November 2, 2018, at the age of 54. His death was ruled a suicide, and the California death sentence was never carried out. Urdiales did all of it alone. The next case involved 4 men working together, and a city that spent 18 months unable to say out loud what was happening on its own streets. Edward Spreitzer. In 1981, a 20-year-old who had been drifting between jobs took a shift at a Chicago donut shop. The man he worked under there had, a few years earlier, been a contractor on the payroll of John Wayne Gacy. Over the next 18 months, those 2 and a pair of brothers left Chicago with a list of missing women that police were never able to close, and a body count they were never able to fix with certainty. Edward Spreitzer was born in Chicago in January of 1961. He struggled through school, dropped out, and moved into a room at the Brer Rabbit Motel. He was working at a Winchell's Donuts when he met Robin Gecht, and from that point, his life belonged to Gecht's ideas. The press eventually called them the Ripper Crew. Gecht organized it. Spreitzer and the brothers Andrew and Thomas Kokoralais carried it out. Between 1981 and 1982, they abducted women off Chicago streets, assaulted them, and ended their lives, and the assaults carried ritual elements that court records describe in detail, and that this narration will not. Linda Sutton was 26 when she was taken in the spring of 1981. Schweimach disappeared on her way home from a family restaurant. Sandra Delaware and Rose Beck Davis both lost their lives in 1982. Rafael Tirado was the only man among them. Those 5 are the cases Spreitzer was convicted in. Investigators came to suspect the group in the disappearances of 18 women and in as many as 17 deaths. And somehow it gets worse, because the man investigators considered the organizer of the entire operation has never been convicted of taking a single life. That gap between 5 convictions and a suspected 17 has never closed. Some of the women were reported missing and never found. Some of the cases sat in different jurisdictions with different detectives and no reason at the time to connect them. Chicago in 1982 had other names occupying it, and a series of women disappearing from working-class stretches of the city did not produce the coverage that a suburban case would have. By the time the pattern was obvious, the group had already been operating for over a year. The group came apart in the fall of 1982. Once the arrests began, statements from inside the crew led investigators to the rest of it, and each man's account implicated the others. That is the structure the entire prosecution rested on. There were no surviving witnesses to most of it. There was very little forensic evidence by the standards of the era. What there was 4 men describing what the other 3 had done. So how does a case built almost entirely on co-defendant statements hold together in a courtroom? In Spreitzer's case, it held. He was convicted in Cook County across multiple proceedings, and in March of 1986, he was sentenced to death. A decision the Chicago Tribune ran under a headline that said exactly that and nothing more. His appeals moved through the state courts for the next 17 years without disturbing the conviction. In January of 2003, Governor Ryan's blanket commutation reached him the same way it reached Urdiales, and his sentence became life without the possibility of parole. He had spent 17 years preparing for an execution date that was removed by a decision he had no part in, applied to the entire Illinois death row at once, for reasons that had nothing to do with his case and everything to do with a system the governor no longer trusted. The other 3 ended in 3 different places. Andrew Kokoraleis exhausted his appeals first. At 34 minutes past midnight on March 17, 1999, he was executed by lethal injection at the Tams Correctional Center, the only person ever put to death at that facility, and the last person Illinois executed before the moratorium that followed. Thomas Kokoraleis served out a lesser sentence and walked free in 2019, a release that drew protest across the suburbs where he intended to live. Robin Gecht was never convicted of a homicide because prosecutors did not believe they could prove one against him. He is serving 120 years on attempted murder and related counts, with a parole date on the books for 2042. Spreitzer's name still surfaces every time one of the others reaches a milestone. When Thomas Kokoraleis was released in 2019, the coverage circled back to the man who was not getting out. When Gecht's 2042 parole date appears in a filing, the same comparison follows, because Spreitzer was the one who talked, and talking is what put the state in a position to convict anyone at all. As of 2026, Department of Corrections records list Edward Spreitzer at Stateville Correctional Center, serving life without parole and ineligible for discharge. He has been in custody continuously since 1982, which means he has now spent more than 4 decades inside for the 18 months that made him famous. Spreitzer was in custody within a year of the last known victim. The next man stayed free for nearly 12 years after his first, and ending it required a federal manhunt, a television broadcast, and a stranger in another country. Michael Alfonso. In January of 2003, the FBI added a laborer from the Chicago suburbs to its 10 most wanted fugitives list and posted a $50,000 reward for information. He had been gone for more than a year and a half by then. What made the listing unusual was that the case that put him there was the second one, and the first had been sitting unresolved since 1992. He was born Michael Johnson in Illinois in June of 1969, grew up in the Chicago metropolitan area, and worked as a laborer. In the 1990s, he legally changed his surname to Alfonso. He used several other names over the years, which is part of why he was difficult to trace. His record started before either woman on this list. In 1990, he was convicted in a case involving the abuse of a minor, and that conviction required him to register with the state for the rest of his life. The specifics of it stay out of this account. 5 years later, in 1995, he was convicted of aggravated battery after an attack on a girlfriend named Josefina Gonzalez, during which he also attempted to remove her young child from the scene. Soumenir Yang was 23, a hairstylist from Wheaton whose family had come to Illinois from Cambodia. In 1992, she was in a relationship with Alfonso, and she was pregnant with his child. She disappeared that September. Her remains were found on November 8, 1992, in Kendall County, near Silver Springs State Park, outside Yorkville. The case went nowhere for years. A woman who had disappeared, remains recovered in a rural county roughly 50 miles from where she lived, and a boyfriend with a record who could be questioned but not charged. Suspicion is not evidence, and in 1992 the file went quiet. Her family spent the rest of that decade watching it stay quiet. Then, in 2001, a second woman entered the picture, and she had recently done the one thing that appears to have set him off in both cases. Genoveva Franco Velasquez, known as Jaina, was 28 and worked at a restaurant in Carroll Stream. She had ended her relationship with Alfonso and reconciled with her estranged husband. On June 6, 2001, she was confronted outside her workplace, and her life was taken there at point-blank range in front of the building, where she had just finished a shift. He was gone before the shift change ended. Alfonso crossed into Mexico and stayed there, using names that had nothing to do with either of the ones he had been born with or had chosen, and moving through a country of more than 100 million people where no one had any reason to look twice at him. The federal listing followed 18 months later, making him the 476th fugitive ever placed on the 10 most wanted list. His face went out on America's Most Wanted and on Unsolved Mysteries twice. On July 15, 2004, he was taken into custody in Veracruz, Mexico, after a viewer who had seen one of those broadcasts recognized him and made a call. A television program produced in the United States was watched in another country by a stranger who identified a fugitive from a photograph and picked up a phone. And no, I'm not making that up. That is how the manhunt ended. So what do you do as a defendant when a charging document lists 2 counts of first-degree murder and the intentional homicide of an unborn child in a state that still had a death penalty on the books? You take the plea. Alfonso pleaded guilty to all of it. The prosecutor handling the case believed the plea was a straightforward calculation, entered specifically to remove the possibility of a death sentence, and the arithmetic supported that read. The third count is the one worth pausing on. Illinois recognizes intentional homicide of an unborn child as a separate offense with its own penalty range, which meant that Soumenir Yang's pregnancy was not treated as an aggravating detail attached to her case. It was charged as a distinct loss with a distinct victim. 9 years after her remains were recovered, that count went on the same page as the 2 women's names. He was sentenced to life imprisonment. There was no trial, no jury, and no appellate fight over guilt, because a guilty plea leaves almost nothing to appeal. Both families sat through a sentencing hearing instead of a trial, which spared them testimony and gave them no reckoning either. The case was later dramatized on an investigation discovery series about fugitives who nearly stayed gone, an episode built around the arrest in Veracruz rather than around either woman. As of 2026, Department of Corrections records place Michael Alfonso at Stateville Correctional Center, serving a life sentence with no release date. Alfonso ran to another country and stayed there for years. The next man never left McHenry County, never raised his voice, and attended all 3 funerals. Charles Michael Albanese. 3 members of one Illinois family died within 10 months of each other, and every one of those deaths was written up as natural. The man who stood at all 3 services ended up running the family business. What finally undid him was not a witness and not a confession. It was a laboratory result. Charles Michael Albanese was born in Chicago in June of 1937, the son of an entrepreneur named Michael Albanese Sr. By the start of the 1980s, he was president of Allied Die Casting Corporation in McHenry County, a title that sounded better than his finances looked, because he was behind on his bank and mortgage loans and behind on his child support at the same time. People who knew him described him afterward in language that stayed consistent from source to source. A spoiled man who wanted very badly to be seen as a big shot. Marion Mueller was 69 years old and the grandmother of Albanese's wife. Mary Lambert was 89, his wife's mother. Both died in August of 1980, within weeks of each other, and neither death raised a flag. His own father, Michael Albanese Sr., was 69 when he died on May 16, 1981. The agent was arsenic, administered in doses over time rather than all at once, which is why the symptoms read to physicians as illness and decline rather than poisoning. Chronic arsenic exposure imitates ordinary things: nausea, weakness, numbness in the hands and feet, a slow loss of appetite and weight. In an elderly patient, all of that looks like age. 2 of the 3 people who died in that family were in their 60s and 80s, and nobody in a position to order a toxicology screen had a reason to order one. He also gave smaller amounts to his brother Michael, who became ill and recovered. Prosecutors eventually put the financial motive at roughly $72,000 in bank funds, real estate, insurance proceeds, and pension money, on top of control of Allied Die Casting and his share of his father's estate. 3 deaths in 10 months in one family, all attributed to natural causes, in a household where one man stood to gain from every single one. You'd think someone would have said something. Nobody did. Not until an investigation was already underway. Albanese was arrested on November 18, 1981. So how do you prove a poisoning that doctors had already signed off on as natural? You prove it with chemistry, and then you let the defendant help you. Because of the publicity in McHenry County, the trial was moved on a change of venue to McLean County, more than 100 miles south, where a jury could be seated that had not read about it for 6 months. Prosecutors put the case together as a ledger. Loans in arrears, support payments missed, 3 deaths, and then a man in control of a company and an estate he could not have reached in any other order. In May of 1982, the jury convicted him and returned a sentence of death. While he had sat in custody awaiting that trial, he made 2 decisions that made his own case considerably worse. He attempted to arrange the deaths of 2 people, his brother and the man who had supplied him with arsenic. And he forged a letter designed to shift blame onto his brother, which investigators identified as a forgery. His appeals ran for 13 years through the Illinois courts. In September of 1995, they ended. He was being held on death row at Menard Correctional Center in the southern part of the state, and Illinois carried out its executions at Stateville. He was flown north by helicopter to Crest Hill for that purpose. On September 20th, 1995, Charles Albanese was executed by lethal injection at Stateville Correctional Center. He was 58, and he was the fourth person Illinois put to death that year. He said nothing aloud. In a written statement released afterward, he maintained his innocence and said the state had not only ended an innocent man's life, it had destroyed his family and everything he had worked for, and had let someone else get away with murder. United Press International reported that he stared at the ceiling for about 3 minutes, took 2 hard breaths, and was pronounced dead at 20 minutes past midnight. The family business did not survive the case in any recognizable form, and the surviving relatives spent the following decade being asked about a man who had sat at their tables and their funerals. His brother Michael, the one who took smaller doses and recovered, lived the rest of his life as both a witness and a target. Having been named in the plot, Albanese tried to arrange from a jail cell. As of 2026, Charles Albanese remains one of the small number of people put to death inside Stateville's walls. Illinois abolished capital punishment in 2011, and the chamber he was flown to has not been used since. Albanese was put to death inside Stateville for taking 3 lives quietly, over months, in a way that almost worked. The next man was convicted for something that took an afternoon, in a state park, in front of nobody, and he spent the rest of his life saying the state had the wrong person. If you're liking this video and you're not subscribed yet, now's the time. We drop new cases every day. Subscribe so you don't miss the next one. Chester Wager. In March of 1960, 3 women from the Chicago suburbs drove out to a state park for a few days of hiking, and by the end of that week, the newspapers had started calling the place where they were found the Canyon of Death. A 21-year-old dishwasher confessed 8 months later, then spent the next 59 years saying he had been made to. He walked out of prison in 2020 at the age of 80. The argument over whether he did it is still in front of a state board today, a year after he was buried. Lillian Uting was 50 years old. Francis Murphy was 47, and Mildred Lindquist was 50. The 3 were friends from Riverside, Illinois, comfortable enough that a few days away in the middle of March was an easy thing to arrange, and they checked into the lodge at Starved Rock State Park on a Monday afternoon. They went walking the next day, March 14th, 1960, into St. Louis Canyon on the western edge of the park. All 3 lost their lives there. They were bound before they were found, and they were not found for 2 days, by which point half the state was looking. What followed was a media event on a scale rural Illinois had never handled. Reporters filled the lodge. The county was overrun. The pressure on the LaSalle County Sheriff's Office to produce a name was enormous and immediate. And that pressure is the reason this case is still being litigated 66 years later. Chester Otto Wager was 21, a dishwasher in the lodge kitchen, a young married man who lived near the park and had a face people recognized. He was questioned early and repeatedly. He took polygraph examinations. Investigators kept coming back to him through the summer and into the fall, and in November of 1960, after months of it, he confessed. He recanted almost immediately. For the rest of his life, he described that confession the same way, as something extracted from him by a sheriff who threatened him, and he never varied the account in 6 decades of telling it. The physical case against him amounted largely to twine. Prosecutors argued that twine available at the lodge matched the twine used to bind the three women. So what does a case look like when the confession has been withdrawn and the strongest physical evidence is a length of common rope? In 1961, it looked like a conviction. Wager was tried for the death of Lillian Oetting alone, and not for the other two, which is an ordinary prosecutorial choice that would take on strange weight decades later. The trial opened on February 13, 1961. On March 3rd, the jury returned a guilty verdict, and he was sentenced to life. He began serving that sentence at Stateville Correctional Center. Over the decades that followed, he was moved through Menard, Pontiac, Graham, and finally Pinckneyville, and he applied for parole again and again and again. He was denied 24 times. That's not a typo, by the way, and some accounts put the number at 23, which tells you how routine the denials had become to the people counting them. The 25th attempt worked. On November 21, 2019, the Illinois Prisoner Review Board voted 9-4 to release him, and on February 21, 2020, Chester Wager walked out at the age of 80, one of the longest-serving inmates in the history of the state. He was not finished. Wager wanted the conviction itself gone, and his attorneys filed a petition asserting actual innocence, which is a far harder thing to win than parole. In June of 2025, LaSalle County Judge Michael Johns denied it. His ruling turned on a point that cuts in every direction, that every witness who testified about how the deaths occurred did so on the basis of hearsay, and that none of that hearsay came from anyone who had actually seen it happen. Roughly a week after that ruling, on June 22, 2025, Wager died of cancer at 86. The case had also stopped being a local story by then. In 2021, a documentary called The Murders at Starved Rock brought the whole thing to a national streaming audience, and it arrived at a moment when Wager was newly free and willing to talk on camera. Whatever it did for the truth, it multiplied the number of people who had an opinion about a 1960 verdict, and it put pressure on a review board that had already been living with the file for half a century. As of 2026, the case is still open in a legal sense. In June of this year, attorney Andy Hale filed a posthumous pardon petition with the Prisoner Review Board, built around a theory that the deaths were arranged and that the husband of Lillian Oetting had a hand in it. Wager's sister, Mary Pruitt, has said publicly that the people who came forward over the years were not all liars, and that the lying and the covering up came from LaSalle County. The petition is pending. The three women have now been gone for 66 years. Wager spent 6 decades insisting he had only said what he was told to say. The next man on this list told investigators exactly where to look, drove out with them, and pointed at the ground. Danny Edwards. On a September night in 1987, a man from one of Kankakee's most prominent families answered a phone call at home, got into his car, and drove off to check on a property he owned. A ransom demand for $1 million followed within hours. Police located him in under 3 days, which sounds like a success until you understand what had been built for him and how it was meant to work. Stephen Small was 40 years old. His grandfather, Len Small, had been governor of Illinois, and the family fortune ran through radio stations and a media company that at one point held a controlling stake in a national wire service. Small spent his own time restoring historic buildings around Kankakee, including a house designed by Frank Lloyd Wright. On the night of September 2, 1987, the call that got him out of bed told him there had been a break-in at one of those properties. Daniel Edwards was a small-time drug dealer in the same city. In a place the size of Kankakee, everybody knows who has money, and Edwards had worked out a plan that depended entirely on keeping a wealthy man alive and out of sight while his family raised cash. He took Small at the property, drove him to a wooded area, and put him into a plywood box roughly 6 feet long and 3 feet wide that had already been buried. Inside, Edwards had placed water, candy, and a battery-powered light. Running up through the soil was a length of plastic pipe meant to supply air. The pipe did not work. Stephen Small suffocated underground while the ransom calls were still being made. Edwards made those calls from payphones around the area. This was 1987, and tracing a call still meant physical work, coordinating with the phone company, identifying which booths were being used, and getting officers into position before the next call came in. The Illinois State Police did exactly that, narrowed the locations, set surveillance, and within a few days had both Edwards and his girlfriend, Nancy Risch, in custody. Edwards then took officers to the burial site himself and showed them where to dig. A man died in a box in the ground because a piece of pipe failed, in a scheme whose entire purpose was to return him alive. So how does a state prosecute a death that the defendant insists he never intended to cause? In Illinois in 1988, it prosecuted it as capital murder, because a death that occurs during a kidnapping is chargeable regardless of what the kidnapper meant to happen. Edwards was convicted and sentenced to death. Risch was tried separately, convicted, and sentenced to life, on the state's theory that she had been an active participant rather than a bystander. Assistant Attorney General Aaron O'Connell later summarized the state's position plainly, that Stephen Small was buried alive because Edwards and Risch wanted to force $1 million out of his family. No money ever changed hands. The family was assembling the cash when the arrests came, which means the scheme failed at every level it was designed to operate on, and the only thing it accomplished was the death of the man it depended on. Edwards left death row the same way several other men on this list did. In January of 2003, Governor George Ryan's blanket commutation converted his sentence to life without parole. Ryan had been a Kankakee pharmacist and a neighbor of the Small family, which made that particular signature one of the strangest in the whole commutation. Risch's case became the long tail of the whole thing. Illinois accountability law allows a person to be convicted of an offense committed by someone else if the state can show they aided it with the intent to promote it, and the state's evidence against her was largely circumstantial, built on her presence, her vehicle, and her knowledge. Jim Ridings, a Kankakee author, spent years arguing in a book called Small Justice that she had been convicted for being in the wrong car with the wrong man, an argument the Small family and the prosecutors rejected outright. Then Edwards started talking again. He signed 2 affidavits and gave a deposition in 2015, stating that he had acted alone and that Risch had been coerced into whatever she did because he had threatened her and her young son with a firearm. Those statements became the backbone of Risch's post-conviction fight. On February 10th, 2022, after more than 30 years, Nancy Risch was resentenced and released. As of 2026, Edwards is serving life, and the honest answer about where is that the public record is thin. The clearest documentation places him at Pontiac Correctional Center as of 2003, and no available source confirms a transfer to Stateville or confirms his current facility at all. His case belongs in any conversation about the men Illinois has held at its maximum security tier, but the address is not something to state with confidence. Edwards buried a man in a field and told police where to find him. The next case put its evidence at the curb on a public street and left it there for the city to collect. John Rowe. On a Monday morning in July of 1990, Two sanitation workers were running a residential route in Lockport, Illinois, when the compactor on their truck tore open one of the bags they had just tossed in. What came out of that bag ended the route and brought every officer in the city to a single address. The house those bags had been set out in front of belonged to a 26-year-old quarry worker whose wife had not been seen in about a week. John Russell Rao was born in December of 1963 and had spent his whole life in Lockport. He had worked 5 years at the Conco Western Stone Quarry near Aurora. His father was a federal meat inspector, and his grandfather had been a butcher, two details that came up constantly in the coverage for reasons that became clear quickly. Sonia Renee Rao was 22. She had married young, and she had a 3-year-old son. In the first week of July of 1990, in the house they shared, her husband ended her life while that child slept in another room. The autopsy would find asphyxia caused by ligature strangulation, along with a blow to the head. What he did afterward is the reason this case is remembered in Will County 36 years later. He separated her remains into 6 parts. He placed them into black garbage bags. And then he carried the bags to the curb on East 14th Street and set them out with the household trash for the city to haul away on its regular Monday collection. Roughly a week passed between her death and that collection day. During that week, her husband stayed in the house, went about his business in a small city where his family was known, and answered nothing to anybody about where his wife had gone. The bags sat at the curb for the length of an ordinary morning route before the truck reached them. On July 2nd, 1990, sanitation workers Rick Gates and Doug Taxis found what was in them. Investigators did not need long. Rao's fingerprints were on the bags. Will County State's Attorney Ed Bermilla told reporters that Sonia Rao's body had been taken apart in a manner similar to butchering meat, a sentence that ran in newspapers across the region and followed the case through every proceeding that came after it. Lockport in 1990 was a town of about 9,000 people where nothing like this had happened in living memory, and the 2 men who found her spent years afterward being introduced as the ones who did. The route was completed by other crews. The house on East 14th Street was searched for days. So what does the law actually do with a defendant who admits to part of a case and fights the rest? It splits the file. Rao pleaded guilty to concealment of a homicidal death and received an extended term of 10 years on that count alone. On the central charge, he was convicted of first-degree murder. Contemporary Chicago Tribune coverage reported a sentence of 70 years. The 1992 appellate opinion reviewing the case affirmed a term of 60 years on the first-degree murder count, which was the statutory maximum available at the time, and that discrepancy between the reported figure and the affirmed figure has followed the case ever since. The appellate court found no basis to disturb the conviction or the sentence. The appeal itself was narrow. Once a defendant has pleaded guilty to one count and been convicted on another after a full proceeding, the ground available to him shrinks to questions of procedure and proportionality, and the First District found nothing in either category that warranted relief. The statutory maximum stood because the conduct after the death, the concealment, and the disposal is precisely the kind of aggravation Illinois sentencing law was written to punish at the top of the range. 60 years in Illinois in 1992 did not mean 60 years. Under the sentencing rules that applied to his conviction, day-for-day credit was available, and the arithmetic that governed his release date was set the moment the appellate court signed off. What Illinois records call parole in a case like this is closer to a calendar than a decision. A determinate sentence with day-for-day credit produces a release date that a board does not have to approve, and the supervision that follows is a fixed term rather than a privilege that can be withheld indefinitely. That is the difference between his file and the files of the men earlier in this video who applied and were refused. On February 24, 2022, John Rao was paroled from Stateville Correctional Center. He had served 31 years and roughly 7.5 months. He was 58 years old. As of 2026, Rao is a free man living in Chicago, having first been released to Channahon before relocating into the city. He is required to register for the rest of his life as a violent offender against youth, a designation that comes from the presence of his son in the house. And his address is a matter of public record for anyone who searches for it. Sonia Rao would have been 58 this year. Their son was raised by other people. Rao was a private citizen whose neighbors had no reason to look at him twice. The next man was paid to be looked at and had a citation from his chief hanging on the wall. Herschel Glenn. In May of 1982, an Elgin police officer who had received a departmental commendation 5 weeks earlier spent an off-duty evening committing a crime his own colleagues would spend the following days investigating. A young couple was taken from a truck at a city park. When officers processed the scene, they recovered a wallet lying about 10 feet from one of them, and the name inside it belonged to a man who had been wearing an Elgin badge that same week. Herschel Glenn had about 3 years on the force. After his arrest, Chief Robert Baird described him to reporters in terms that must have been painful to say out loud, as an extremely fine officer who had never been reprimanded and had never been a disciplinary problem. A man who had been given a special citation for efficiency barely a month before. James Wright was 18. Lillian Final was 20. The two were a couple from Streamwood, and on that evening in May, they were sitting in Wright's truck at Lord's Park in Elgin, which was the kind of ordinary thing that thousands of couples did in that city every week. Both were taken from the truck. James Wright's life was taken at the park. Lillian Final was assaulted, and her life was taken as well, and her body was recovered later in a field behind an industrial plant near the Illinois Tollway, some distance from where the evening had started. A sworn officer took 2 young people out of a parked truck in the city he was paid to patrol, and the department that went looking for them was his own. The wallet was the beginning. A witness had noticed a vehicle and remembered enough of the license plate to give investigators a direction, and that plate traced back to Glenn. A search of his home produced clothing with blood on it and a weapon of the same caliber as the one used at the park. Within days, the Elgin Police Department was executing a case against one of its own officers, and 2 counties were preparing separate prosecutions because the crimes had crossed a county line. So how does a jury weigh testimony about a defendant who had spent 3 years testifying as the state's own witness in other cases? In this instance, it convicted him twice. A Cook County jury found him guilty in the death of Lillian Final and in the assault against her. Kane County prosecutors convicted him separately in the death of James Wright. The sentence was natural life, plus an additional 30 years on the assault count, with no eligibility for parole at any point. The 2-county structure mattered more than it might sound. Because the couple was taken in one place and Lillian Final was recovered in another, 2 separate states' attorneys built 2 separate cases on overlapping evidence, and each had to prove its own elements to its own jury. A failure in one courtroom would not have undone the other. The state, in effect, gave itself 2 chances, and it did not need the second one. He appealed, and in 1992, the Illinois Appellate Court, 1st District, affirmed in an opinion written by Presiding Justice Buckley, reported at 599 Northeastern Reporter 2nd, page 1220. That opinion is still the last substantive judicial word on the case. For decades afterward, the answer to where Herschel Glenn was located was simple. CBS Chicago reported him serving his life sentence at Stateville Correctional Center, and that is where the record sat. Then it stopped. In the spring of 2020, as coronavirus moved through Illinois prisons, Glenn, listed at that point as 61 years old, was granted a medical furlough. He was reported as one of 164 people convicted of homicide who were furloughed or had sentences commuted under Governor J.B. Pritzker during that period, a figure that generated significant political argument at the time. The furlough program was intended for medically vulnerable people in a system that could not distance them from one another, and the great majority of the releases drew no attention at all. The ones that did draw attention were the ones like this, where the name attached to the sentence made the medical rationale hard for the public to hear. As of 2026, there is no public record establishing what happened to him after May of 2020. Nothing published since confirms a return to custody, a death, or an address, and the state has not been asked publicly to account for him. A man sentenced to natural life without parole for taking 2 lives passed through a prison gate on a medical furlough during a pandemic, and the public record simply ends there. What the Elgin Department lost that spring is harder to measure than a sentence. A city learned that a man it had commended in writing, for efficiency, 5 weeks before, had used everything the job gave him: the training, the credibility, the assumption of safety a uniform creates, against 2 people who had no reason to be afraid of him. Glenn's story ends in an absence of information. The last man on this list built an entire second identity out of information that was never there to begin with. James Files. In 1994, a private investigator sat down across from an inmate at Stateville who told him he had fired the shot that ended the life of President John F. Kennedy. He described the weapon, the position on the grassy knoll, and a shell casing he said he had bitten down on and left behind as a calling card. The account has been examined by serious researchers ever since, and the phone records place him roughly 800 miles from Dallas that day. James Earl Files was born in January of 1942 in Oakman, Alabama, and has also gone by the name James Sutton. He has claimed service with the 82nd Airborne in Laos and a working relationship with the Chicago organized crime figure Charles Nicoletti. Those claims are part of the story he tells about himself, and none of them have been independently established. What is established sits in an Illinois court file. On May 7, 1991, in Round Lake Beach, Illinois, Files attempted to take the lives of 2 police officers, David Ostertag and Gary Bittler. He was convicted of attempted murder and sentenced to 50 years. That conviction is the reason he was at Stateville, and it is the only violence in his history that a court has ever found him responsible for. 3 years into that sentence, he told private investigator Joe West that he had been the second gunman in Dealey Plaza on November 22, 1963. He named the weapon as a Remington XP-100, a single-shot pistol nicknamed the Fireball. He said he had fired from behind the fence on the knoll. The interview was filmed, and in 1996 it was released commercially as a video titled Confession of an Assassin, which sold well and has never gone out of circulation. The account did not survive contact with investigators. Edward J. Epstein, one of the most rigorous researchers ever to work on the Kennedy assassination, went at it with the corporate investigator Jules Kroll, and telephone records they obtained placed Files in Chicago on the day of the assassination rather than in Texas. The analyst John Stockwell went through his statements line by line and documented factual errors in what Files said about Lee Harvey Oswald, about Sam Giancana, and about the CIA officer David Atlee Phillips, errors of a kind that someone with actual inside knowledge would not make. There is a pattern here that predates him. Long-sentence inmates have been confessing to the Kennedy assassination since the 1960s, because a man serving 50 years has nothing to lose, a great deal of time to read, and access to visitors who want very badly to believe him. Files had the reading, the time, and a real Chicago organized crime periphery to gesture at, which made his version more durable than most. So why does a claim that has been checked and found empty keep finding new audiences? Because the legal system never had a reason to touch it. No prosecutor charged James Files with anything relating to 1963. No court ever ruled on the truth of the confession, and no judge ever entered a finding that it was false, which leaves a permanent gap that his supporters have filled for 30 years. The only sentence he ever served was the 50-year term for the attempt on 2 Round Lake Beach officers, and he served roughly 25 years of it. In the late spring of 2016, the Illinois Department of Corrections released him on parole. His full discharge was reported around 2019. The people it costs are not abstractions. Every hour spent on a confession that phone records already answered is an hour not spent on the documented parts of that November. And every retelling puts the Kennedy family's worst day back into circulation as entertainment. The confession has outlived the sentence by a wide margin. There is a book published in 2008 under the title Files on JFK, a documentary released in 2024 timed to the 60th anniversary, and a permanent presence in the assassination material that circulates online in every language it has been translated into. None of it has ever produced a document, a witness, a photograph, or a record that places James Files in Dallas on that day. The strongest thing on his side is the one thing that cannot be disproven, which is that he says he was there. None of it factored into the only decision that ever mattered to his liberty. The Prisoner Review Board considered a 50-year sentence for the attempt on 2 officers, the time he had served against it, and his record inside, and it released him on that basis. The most sensational claim ever made by an Illinois inmate was legally irrelevant to the question of when that inmate went home, which is either reassuring or unsettling depending on how you look at it. As of 2026, James Files is in his 80s and living as a free man, discharged from Illinois custody with no supervision remaining. The 2 officers he was convicted of attempting to take from Round Lake Beach are the only part of his story a court has ever certified as true. Stateville has held more infamous names than any other prison in Illinois, and as of 2026, some of the men in this video are still inside it. Some are free, and some are gone. The records that track them are public, and they are worth checking before you believe anything anyone says about where these cases stand. Thanks for watching. Click here for the next video.